Dear students, good morning to all of you. Now, I think you all understood the topic relating to admissions, confessions, dying declarations, and opinion expressed by another third persons. Those who are not related to the case, but we are taking their opinion as significant or important because why we are allowing a third person who is not at all related to the case to give his opinion and why the judiciary is depending on their opinion to come to a conclusion relating to occurrence or non-occurrence of any issue. Who are these third persons? Why court is allowing them? Madhuri, who are these third persons? Why court is allowing them? They are not related to the case. They never saw the incident happening. Still court is allowing them. Why? Sangameswar, Sridevi, why court is allowing those persons who never ever had any relation with the occurrence or non-occurrence of an incident, still court is basing on their evidence. Their evidence is going to become a deciding factor. What the subject we studied in the last class. Because one day gap came, we forgot. Sridevi, can you all hear me? Shivasankar, Shivasankar, Madhuri, Sridevi, only three persons. Sirisha, Sirisha and my madam. I don't want that good morning. What I am asking is, we are discussing about the evidentiary value of the statements. Admissions made by the persons who related to that case. Confessions relating to the persons who committed the offense. And some other persons also giving, and some other persons who saw the occurrence of the incident, and the other persons who were a party to the particular incident are coming and giving the evidence. And certain documentary evidences also we are taking to decide the facts. But some persons who are not at all related to the occurrence or non-occurrence of that particular issue are coming to court and giving their opinion, and that it is becoming a crucial fact to decide the case. Who are they? ఎవరమ్మా వాళ్ళు? విట్నెస్ కాదు. విట్నెస్ అందరు విట్నెస్లే కదా. We all are witnesses. The first witness will be the person who filed the case. అమ్మా పద్మా సుసర్ల. మొత్తానికి at last I got the answer. It is the expert. An expert's opinion is going to be crucial thing to decide the occurrence or non-occurrence of an incident when we ourselves cannot come to a conclusion. We don't know who wrote the particular document. Then if you take the help of judiciary, do you know one thing? How a forgery will be decided? When a particular signature is forged by a person, the person who is forging the signature will, as it is, he will copy makki to makki the strokes of that particular signature. It is why these experts generally will ask the persons to sign 3-4 times, and they compare whether the signature is as it is coming like the original one or not. That is what they will be. The one which 100% tallies with the original one is the original one, because same person, even if it is same person, cannot sign in the similar way second time. No two signatures will tally. When they are tallying 100% equally, it means it is forgery. Original matter have variations. Yes, original must have variations because strokes will change from signature to signature. Sometimes after a long period of time, 100% change will come in the signature, so that the officials who are receiving, I mean bank officers or postal departments, whoever, wherever you are having an account, you are regularly visiting, those people may get a doubt that the signature may be forged. In those conditions, they even ask you to come again, and if you yourself notice that there is a lot of variance in your signature, you can go to that particular department and you can hand over your recent present signature so that you can avoid the forgery. Therefore, these are the persons who are known as experts. These experts are giving their evidence basing on two things. What are they? First one, because of their scientific knowledge. With the reasoning, because this thing happened, it is the result of so and so particular things. Like this, they will give an opinion and they give conclusion, evidence relating to it. But in certain conditions, these people are not having any particular clue about the occurrence of that incident. Still, they will give that opinion because they are experienced. Similar kinds of postmortems they did. In all other postmortems where they attended, they noticed the similar kind of thing. In those cases, a conclusion came basing on the facts in so and so, and those cases are completely closed. So, basing on that evidence, now in the present case, they will give their opinion. The second kind of opinion may or may not having the significance basing on the facts, but the first kind of one is always having the significance. And in certain other conditions, even though the persons who are giving the evidence as an expert may not have any special degree, there is no need of any specific special degree to a person. Do you know S.P. Balasubramanian, S. Janaki, number one famous singers of our Telugu industry are not trained classical singers, but see how great she is without having any knowledge. She sang so many classical songs. Till today, no one is there to sing those songs like her. But she is not a classical singer. So, with the, why, how she sang like that? What is the specialty? Now they might have, after staying back in the same profession for 30 years, 40 years, maybe they have become now knowledgeable persons. They might have learned the music now, but in the beginning stages of their career, when they started their career, when they sang these famous classical songs and became singers, they are not classical experts. Still, because of their expertization in that particular field, hard work, they later they have got trained exactly. Later they got trained, but when she sang that song Neelila Padida, she was not a classical singer. That is what I am saying. So even though you are not an expert, even though you are not having any specific degree, because of continuous work or because of some other thing, when you become an expert in that particular field, you can give an evidence. Like this only, family members and other relatives and some other business people, when they are coming there, we will take their evidence. So when you are working in any organization, Ramoji with that Margadarshi organization, I noticed when my friend used to work there, they will get diaries for every year on Jan 1st. Whatever may they get other things, I don't know. But what is the significance of that diary? Presently, I don't know. 10 years back issue I am telling. What is the specialty of the diary given by Ramoji groups? Is every diary will be signed by Ramoji Rao himself. Whether he did it or not, and I cannot say no. I never saw. Even the employees also not seen it. But because they won't get the opportunity to see the boss every day, but they are habituated to work in the organization by receiving the instructions from the next grade officers. And these people again entrust the work to somebody else, and those persons are again doing. This is a routine phenomenon in the work process of that particular organization. In that condition, all the persons who are working as a chain are having significance as a witness, and they all can depose before the court relating to identification of a particular incident related to this particular process. So these are the experts. So experts means the persons who are having special skills, scientific knowledge, and the persons who are not having special skills, but they are expertised in that particular field and habituated in doing that work. And the third one, the persons who are closely associated with the fact and issue. So, fact and issue, if is my handwriting can be identified by all my students, all my friends, all my relatives. Whoever can identify my handwriting, they all can come and depose. Like that only if it is the expertization relating to any custom of any area, from that particular locality, from that particular caste, or from that particular area, wherever that custom prevails, from that place, all the persons relating to this custom, elderly persons can come and say that there is a longevity from so long period that particular custom is prevailing in their area, hence they can say the same. And like that only when it comes to relations between two persons, whether they are related or not, whether they are mother, wife and husband, mother and father, son and parents and children, then this type of parentage, other issues, legitimacy of a child to be decided. Generally, court feels that no child is illegitimate because it is not, of no part of the child he is going to become victimized. Hence, he is given all the special consideration in the property matters and other things. Therefore, basing on these things, when any person is challenging, of course, there is DNA nowadays. When there is not DNA is not available, when it is not possible to take the DNA of a dead person, in those conditions also, they will take the help of the experts. And the experts means the neighbors who regularly watch these two persons in the official records of schools, colleges, or some other places. Sometimes they take them as in adoption. At that time, they print a card, invitation card. All these things are going to take a crucial place like experts. So these persons, if comes and says that yes, even though they are not wife and husband, they are living together, it is going to be treated as expert evidence. So these are the sections which you might have understood now, I think. Any doubt if you are having, so maximum number of students came. Now I can go to next topic. Before am going to next topic, I want to ask you whether you all followed about experts or not. Think you are following. I will go to the next topic, that is character when become relevant. Whether a judgment in any case is going to be decided basing on the character of a person. Means whether the law permits a good person to, okay, whether a good person is permitted to commit any offense, whether there is any classification to decide the punishment as good person and bad person. Good persons will get less punishment, bad persons will get big punishment, and good persons will be given some privileges in matters relating to civil cases like this. Is there any special thing you heard ever? Why you people are not answering? Is there any classification good person and bad person? How will he become a good person after committing a crime? How will he become a good person after committing a crime? Is after committing the crime, he may not be a good person, but before committing the crime, whether he can put a tag before any person and call him, he is a good person, he is a bad person. So this kind of persons, see in the previous era when Britishers are there, they used to take the evidences of people in different way. Basing on caste wise, evidence will be recognized, and like that only gender wise, caste wise, they divide. This is Article 14, equality before law. Okay, article you speak it with your constitutional law, sir. But what I am saying is, according to evidence, character is so anyhow your constitutional subject knowledge you are using here. Therefore, finally, circumstantial evidence. No, it is not circumstantial. No one is good, no one is bad. All are equal before law. There is no differentiation before law. Law takes everyone equally, and if anybody makes any wrong thing, but in certain cases, character is going to become a crucial thing to decide the fact. There only few cases. I am asking this question because alien entered into the program. Therefore, I am asking this question. Otherwise, I wouldn't have asked you. I myself told the answer. I am expecting an answer from you. Where court is going to take character as a important thing to decide a particular case. No prejudice of a person shall prevail over deciding any matter. No way, no how. So, in some cases where the case itself is filed basing on the defamation, when defamatory state basing on the defamatory statements, if a case is filed, their court is going to take character into consideration and decide the case. Except defamatory matters, in all other matters, previous good conduct or bad conduct is not going to be taken into consideration. Okay, but ma'am, in jails also, due to their good behavior, their punishment will be reduced. See, after sending into the jail, there again you better ask this question your Padma madam. She will answer. Anyhow, because you asked me, I am telling. To give the punishment, there are different procedures. Defamatory theories and other punishment theories are there. Basing on them, to encourage a person not to commit the similar kind of offences, and they are taking certain steps, except that a question is on character of the one accused or plaintiff exactly. So, then the case itself, that is what you have to understand. Because therefore, when it is going on happening again and again, uh, people will be habituated to go to jail. Therefore, to encourage them that if you work properly, if you behave properly in this society, you can be a part of the society and you can lead like all other people. And to encourage the people, punishment or some rebates and other things are given, and it is one among them. But at the time of deciding the case by the court, 100% for judiciary, all are one and same. There is no need of taking the character into consideration based on certain conditions because particular this problem comes on in two matters. One is defamatory matters where character assassination will be done by a person against the other one, and there a defamatory case is filed here. Whether that particular person is having the character or not, whether these particular words which we are calling as defamatory statements are not, is to be decided. While studying about the transactions of same part in the previous sections, we studied that if the defamatory statements are made in any letter or in a statement, you have to take the entire statement and all the letters into consideration to decide whether that particular word is defamatory or not. So, when maybe they will commit a crime sometimes in a anger or based on their whatever may be the reason. To go through Nanavati case, whatever may be the reason, how great he may be, if he committed an offense, he will be punished. That is why Godse case also you can take as an example. Gandhi himself requested to leave him, but the court did its work. The judiciary is not going to give any kind of excuses to anybody, but if at all, after giving the punishment, if there a change is observed in their behavior, basing on that condition, again, your constitution has some pardoning power, and there is a power to presidents and governors where they can reduce the punishment. According to that process, as an administrative matter, if government takes a decision, then they may change the punishment, and according to that procedure only, when a person is in jail and is having good conduct, if jailer certifies and the authority satisfied, they may excuse him, rebate will be given to them. And in some other cases, apart from defamatory cases, where we assassinate the characters relating to the cruelty, sexual harassment of a woman. In those cases, people always wants to prove that so and so woman is characterless because of that nature. She herself cohabited with me. It is not a rape case now. She is filing false cases. You all witnessed that punishment may vary based on the intensity, intention, damage, and other elements, but punishment will be given. Exactly, it depends on the circumstances. How far the advocate is successful in convincing the judiciary is the matter here. If you can submit all the evidences in a proper systematic procedure and convince the judiciary that because of sorts of conditions, in a helpless condition, he did this offense and he himself is admitting his crime, and certain conditions will be there where there is a possibility for judiciary itself to take a decision to reduce the punishment. But punishment is equal to all. That reduction of the punishment is because the facts submitted to the court are something which says that the person deserves that reduction of the punishment. Hence, court is reducing the punishment, but not because his character is good or he is great. Even recently, actually, I forgot the case. If Srikanth remember it, he will mention the name. In Karnool, one big family is there. He is some church father or some other temple somewhere. He worked and he donated so many things to so many people. He worked in orphanage also. After a long time, it came to the notice of the people that he committed some murder. it became a big issue in the beginning stages when police went there with a suspicion. Big havoc is created in the state. Why people went to that such a noble person's house, but later it is proved that he himself, I think, accepted that he committed that particular murder, honor killing. So these type of things are very common. So once if he admits that he committed the offense, there will be no excuse. Absolutely, there will be no excuse to him. Okay. Now, best example is murder versus culpable homicide. Exactly. I don't want to touch that point. If I touch it, I know what you are next going to ask. In criminal cases, previous good character relevant, and in criminal cases, they are going to take previous good character means, as I said, just we discussed intensity and whether it is a sudden provocation, whether he is did with some other motive or not. All these things, basing on the severity of the situation, punishment will be decided. It is a punishment will be up to 10 years, up to 14 years. Means all the 14 years punishment need not be given by the court. Court will take all the things into consideration, but basing on the character, they are not going to do the punishment. Like that, only bad character is not at all going to be taken into consideration. They may take previous good conduct and if you pray before the judge that unintentionally, unexpectedly, I committed this offense, please excuse me, I came from this poor conditions, my environment is like this, like this. If you went on requesting, they may consider, but you cannot take the previous bad character as a base for the cases, particularly the rape cases, other cases, when they are filing cases against women, those cases are not going to be taken into consideration. Okay, and the next section is evidence of character or previous sexual experience not relevant in certain cases. As I said, like this, here in those cases where previous conduct, they may be having a long standing relationship, but in this particular occurrence, without her consent, if you harass her, it is going to be a punishable offense as per the law. Again, except in certain conditions, previous bad conduct is not going to be taken into consideration. So, only for damages, previous conduct is going to be taken into consideration. Now, if any one of you are having any doubt relating to this particular chapters, ask me. Otherwise, I will proceed. Because now, if you understood from section 1 to 16, a conduct, a character, occurrence of an incident, all these things which are going to become a part of the same transaction. Even though they are not related to this transaction, how you have to connect them basing on the sequence of the issues. These things you studied there. And from section 17 to 32, you studied 31, you studied about the confessions or admissions, statements made by the persons who are the main parties to the case. And if those statements are related to the occurrence of a or non-occurrence of a fact, it is an admission. If it is about occurrence or of a offense, particularly if they are self-forming statements, they are having evidential value 100% paka. So those statements are going to be taken into consideration. In this one, admissions need not be by the same person. Admission of some third person also can be your admission. How? When you allow the agent to wakalat, you are giving the wakalat to an advocate and saying that whatever he says in the court, I am binding by it. Therefore, when you give the wakalat to an advocate, advocate's admissions are going to become your admissions. Like that only when you are allowing your family members to say something, you permit your mother to go for a particular marriage alliance and she selects a girl and you are ready to marry her. In the last stages, you cannot say that it is a selection of my mother, I don't have any connection with her. So because you allowed your mother to do some work on your behalf and you allowed your family members or sisters, brothers, and in some other conditions, in front of so many people, some thing is happening. When I came to college, in front of all the students, somebody insulted me. And all the students at that time sympathized and said, oh, madam, you are really insulted. Something, what happened is very bad. So, believing that you all people are going to come with a lot of confidence, I gave a statement in the court that if you want, you ask all the students of KV Rangareddy Law College. They will come and give the evidence. Means here, the admissions are by so many persons. I am not giving to one single person. Out of these so many persons, one person comes there and says that, no, whatever madam is saying is wrong. Actually, she is trying to influence our mind. And if we use a thing, then automatically 100% I am going to face a problem because it's going to become my admissions. Therefore, when you are stating before the court that so and so persons are coming to court and giving an admission on my behalf, I must be careful because once if I admit that I am going to bind by the statements made by so and so persons, if those persons comes to court and gives any statement against me, it is an admission against me. I cannot take it back later. So all these kinds of admissions, admissions by family members, admissions by some other persons, admissions through a long process. Sometimes I wrote a letter to X and X wrote a letter to Y and then Y related to the other party. And in this process, a chain of process, when the case is going on, he got the information from here and he submitted those books there. Accounts books he maintained. All these things are going to become your admissions. Diaries you are writing, so all these things are going to become evidences. You must be careful at the time of making these admissions. Like that only confessions also when somebody forces you to give a statement. A statement given before a police officer is not valid. Statement given before magistrate is only having a lot of evidentiary value. Under those conditions, when you are making a statement, be careful that if at all police or somebody else threaten you or force you to make a statement, and immediately the first time when you meet the judge in the court, the judge will ask you, "Neram chesava," whether you committed the offense. He will ask you when judge asking you, you are supposed to answer him immediately. If you fail to answer, then court will take the statement as your own statement only if you repeat the same thing. So when it comes to the second one, in the meantime, one student Rimi is asking me section 49. She wants to know what is section 49. Section 49 is about opinion as to usages, tenants, and when relevant, etc. When relevant means it is generally relating to customs amount. When, madam, if we admit X to be an evidence in the matter, later if X denied to present himself in front of court, how to deal with it? I will tell it later. First, let me answer Rimi because she is asking me about section 49. Section 49 deals with the generally opinion of experts only. When there are certain customs which are prevailing in your area. 3 months back, one person came to my office for a case. His son-in-law filed a divorce case about which he want to discuss with me. While discussing that case, confessions to police or anyone other than the competent persons to record a confession, such as judicial, will not be considered at all. They will not be considered. If there is any corroborative evidence, then they will be considered. For that only I am telling, when the police take any statement, you are supposed to inform to the court. If court asks whether the statement made by you at the police station is made by you or not, he is supposed to say, I am not related to that statement. Because the police officer threatened him, he gave a statement before the police officer. It became confessional statement. And the police along with charge sheet submitted that statement to the court. And at the time of inquiry, when court is asking him, he is supposed to say that this confessional statement is not given by me because of the force and fear I gave it. If he fails to say it and he admits that it is his statement, then second time he is admitting before the court. Therefore, it is having the confessional value. That is a small difference between a confession made before a police officer and a confession accepted second time ratified by him before the judiciary. If he ratifies it before the judiciary, then it is going to be having a judiciary value. Okay. Then when a custom, section 49 deals with customs and other traditions which are going to be followed by the people in their areas. There, a particular class of people who are there to decide what is going on in a church, what is the procedure to be followed during the prayers and all other things by that particular religion people. In temples, how they are going to do. If you go to any particular village, in that village, what is the special custom? Yesterday I told you that women used to tie the Mangal Sutra in that particular area to men. If I say it, you may laugh. This is a glass, but it so happens this news came in the TV, one of the famous TV channels. Therefore, it might be right. And the news channel at the time of saying the news, they said about it. Therefore, it might be correct. Like that only, as I told you, a client came and he is saying that his son-in-law filed a divorce case, and I read it, and according to that case, whenever son-in-law is asking, his daughter is not going there, he said. Then son-in-law mentioned that there is a system called ILATM. Whether that system is there or not, I asked him. He said, no, he is writing wrongly. Then let him prove it. That is what I told him. Sir, if it is there, then we can prove our custom. If it is not there, then let him prove. Therefore, like this, personal matters law, when the cases comes before the judge, there what the parties will do in matrimony, this is our custom, this is the custom of the other party, which I fail to accept. Like this, they will mention. Actually, this type of special customs, whether in existence or not, is to be decided by the court basing on the evidence of some experts, elderly persons of that particular caste, particular religion. When it comes to decide about the religion heads are going to decide whether it so happened or not. If the people like our this student have come wants to say something against those religious heads, he is at liberty to say it by stating that so and so things happen, so and so things not happen. We are not, because for Hindu religion there is a possibility for every person to speak against the religion. In other religions, particularly, they are so rigid, and even then, if it is possible, you can speak. But the opinion of the heads of that particular departments are going to be going to prevail, not the opinion of the ordinary persons. The simple reason behind this is they are the persons who well aware with the facts. Like that only, in our colony, there used to be a small way. Now that passage is not there. Whether there is any passage in existence in the land back or not. If so, that passage belongs to my neighbor, not mine. Now I encroached into that passage. Who will decide it? After a long period of 50 years, the people who stayed here 50 years back, they are going to experts. Their evidence is going to prevail relating to this particular issue. Like this, when any particular issue related to something which is not there in textbooks, if it is there in any books, if it is, the evidence is, if the documentary evidence is available for it, generally for customs there won't be any documentary evidence. It pass on from one generation to another generation. Usage or custom, they will pass on from generation to generations. Therefore, when these things are taking place, those matters can be decided by the persons who are having knowledge relating to those issues. In that particular area, whoever are the elderly persons, they are going to take into consideration. Now, next question is by Pandey. Madam, if we admit X to be an evidence in a matter, later if X denied to present himself in front of court, how to deal with it? Yes, X statement we said that we are admitting with confidence, but later X said that something against me. Immediately, if we are having the confidence that we can prove that X is wrong, we can request the judiciary to declare him as a hostile witness. Then this topic will be covered in the later sections, but still I will give some small information relating to it. So when we declare him as an hostile witness, we get an opportunity to cross-examine him. If we are simply silent, his statements are going to be used against us, and they are our admissions. And 100% based on admitted facts need not be proved. This is what we studied in the starting section, section 3 and 4. While studying there, presume, presumption, shall presume, may presume, conclusive proof, these things we decide. Basing on certain things, finally court will come to a conclusive proof, evidence, and court will declare that occurrence of that incident or not. Under those circumstances, when a particular statement is made by a person and we are admitting it knowingly or unknowingly, then it is going to become a crucial fact to decide the case against us. Therefore, whenever any statement is made by a person whom we brought as a witness into the court, we must request the judiciary to declare him as hostile. If we are not requesting the court to declare him as a hostile, and if we are allowing him to speak against you, then you cannot cross-examine him, and his statements are going to be a crucial things to decide the case. You will ask the case on appeal. Therefore, immediately ask the court to declare him as a hostile, and you will get an opportunity to cross-examine him. And in that particular cross-examination, try to prove that his statement is not having creditworthiness, not himself. His witness creditworthiness is different from the creditworthiness of the statement. That statement is not having any value because of some other reasons. He is giving false statement before the court. He proved like that, and he proved that there is lot of contradictions in his statements. Then definitely his evidence will become invalid. Next question, confessions to police or anyone other than the competent persons to record a confession such a judicial will not be considered at all. Just now I answered this thing. So confessions are again except before the magistrate. If you give any confessional statement before others, its admission is something doubtful. But when you admit something, that admission is going to be recorded by the police at the time of investigation of the case, and along with charge sheet and other documents, they will submit these admissions to the court. And there, when the trial start or the prosecution of the starts the case, at that time when court asks, he is not supposed to admit them. If at all he admits them, then 100% he is binding on them. Because if somebody forced you to give a statement, you can say the same thing at anywhere. One example I will tell. When Orthodox family, when I started my practice, I noticed this couple in the court. Wife and husband came to court. That lady actually is a graduate or postgraduate. I think, as far as I remember, she might be MA. She might studied MA. And these two persons married at the age of some 18 years or 19 years at an young age, and she failed to adjust with her mother-in-law. Day-to-day life, they started to face so many problems. And on one particular day, husband convinced her to get rid of my mother's problem. You simply come to court and say that you are interested in mutual consent. We both will take divorce. My mother will be happy. But that divorce paper is only to satisfy my mother and to save your life from the hands of my mother's harassment. But I will take care of you. You are my wife, and we will live together. I will keep you in a separate house. He promised her like this so many things, and she thought that she can get rid of her mother-in-law. She came out of the house without informing to any family members and others, and she accepted mutual consent. First time she filed the case. Second time she appeared to take the divorce from the court. In both the cases, judiciary asked her judge. They will put a question to at least one person will be asked by the court at the time of filing any petition whether you signed it with free will or not, whether there is any compulsion, whether you received any compensation or other things from this one, or whether you are interested in asking anything. You can ask the judiciary like this. Court will ask a question. When the judge asked her, there she said, no, out of my free will, I am giving this divorce, the signature is mine. After that, court granted the divorce. For 4 years, according to her, they lived together in a separate house. All of a sudden, after 4 years, he stopped visiting her. And then she noticed that she revealed all these things to family members. Then they cried, and along with her brother, she came to court for reopening of the case. And in the meantime, she is having some photographs where they attended the marriage functions of some of the relatives after divorce. So after divorce, why I attend the marriage functions of his family members? Because I don't know that this divorce paper is going to be valid. Here, her confession is before her husband, the confession is before mother-in-law only, but that confessional statement which she did the signature, when came to the notice of the court, there judge asked her whether you did the signature with free will. There she said yes. Now she cannot. Court granted divorce. Her plea was rejected by the judiciary because so wherever you sign any document because of any kind of force or any other thing, it's a minimum expectation that once if you come to the judiciary, before the judge you must open your mouth. It is why I regularly ask all my students, please, there will be no minus marks, no punishments to any one of you. Please try to speak something or the other. Please don't be silent. Regularly ask that only because you must be habituated to speak. Otherwise, in your life also, you are going to face problems because of your silence. So many times you will face problems. Second thing, an advocate needs courage. That courage you will get only when you start to speak, good or bad. If you fight with your lecturers, then also it is correct. You can fight with them. Fight means don't make personal accusations, but if you make personal accusations, again, people like me, they will take lightly and they will make again the same accusations against you. There won't be any problem. But fact-wise, if you don't like a particular fact-wise, you can be successful. You can fight with anybody. No one will take it seriously if you are fighting fact-wise. So now I think I cleared the doubts of all these persons. So Madhumati, if there was any agreement made between them, Will the agreement produced later will be the, that is what I am saying. Nothing will be accepted because she came to the court and she deposed before the judge that so and so document is my own admission, my statement. This admit, first one may be fraud. First one may be an agreement which is made because of the undue influence, force, threat, whatever it may be. But the second one, what she made before the judge, is not going to be made by her because there she ought to tell to the judiciary that my husband made like this, there is an agreement. So she is also become a part of that particular wrong thing. Therefore, ignorance of law is no excuse. She is not going to. But one thing, what she can do is, if she is having ample evidence with her that her husband cheated her, then with that evidence she can file a cheating case. I don't know whether to which extent there also she will get success, but there may be a possibility to some extent. It depends. If that case goes up to High Court or Supreme Court, because lower courts generally are fact-finding cases. They're basing on the law only, they will decide the matters. There will be no deviation from the law in the lower courts. High Court and Supreme Court can interpret the law and they can make amendments to law basing on the conditions. So therefore, there you can ask for, you can challenge the law in High Court or Supreme Court. In lower courts, generally you cannot challenge the law, there won't be any use of it. But if she can fight it in Supreme Court, there may be a possibility that the High Court or Supreme Court may consider it as a fraud. But as far as, because I am an outsider, I sat there in the court because I don't have any other work. There I noticed the case of another advocate. The facts which I noticed are these. And according to that, when the court asked, she is saying that she is having the evidence of photographs where she attended to the marriage functions of her husband's side people. That is not the big issue. Even after divorce also, if there is good relation with all the family members of husband side, they may call her, they may invite her. We have seen so many people and she will attend those functions. What is there? Except with husband, she can maintain relation with all the other people. They may call him, call her. If they are having some issues, then children may be taken care by both the families. There is, because it is after taking mutual consent. Even if it is a contested divorce case, there is a possibility of having connection with the family members of husband relatives. Under those circumstances, those photographs, if are there, they are not a good evidence to call him as a fraud. But if really, she is 4 years time. It is, she is saying 4 years means she might have a lot of ample evidence with her that they both are living together as wife and husband in a particular portion. As Section 49 says, taking that thing into consideration, she can definitely challenge the husband. But what she did, I don't know. But so what I am saying is here the most important thing, when any confessional statement is made before the, it is why if you observe the police officers also, when a confessional statement made, they simply are not going to take that confessional statement and declare that so and so person committed offense, so and so person gave the confessional statement, hence we concluded the case. Like this, no police officer is giving the statement. After getting the confessional statement, they will make an inquiry related to this particular incident and they will try to get corroborative evidence. After getting the evidence, then only they will declare that case is closed. We find the evidence and these are the evidence. If it is a big sensational case, they may give press note. Otherwise, they submit everything to the court. Okay. Now, next, let us go to next section. Section 55 of next one, proof. What is meant by proof? So now statements are over. How many kinds of statements are over? Now you can remember. Statements which are becoming a part of the same transaction even though they are not related to it. This is the first part. Second one, admissions. Third part, all these things I am telling because 2-3 students asked me how to remember the sections. You divide the topics like this according to your convenience. If you divide the topics like this, you can easily remember the sections. And next one, confessions. Tarvata dying declaration. After that, the facts which are relevant. And the next section is related to the proof. Facts which are going to be taken into consideration, judicially noticeable and judicially not noticeable issues will be there. What are they? These things we are going to take into consideration. What is the time now? This 10:15. Shall I continue the topic? Next topic. How much time? 45 minutes. So one or two sections I will tell. Then I will stop it. Okay? Because Section 56 deals with the fact judicially noticeable need not to be proved. Judicially noticeable means what? AA items, ignorance of law is invalid. Okay, madam. What government should have a reasonability to educate about law to everyone is important, madam. It is everyone. It is important. One government can do nothing because chief minister requested all the people. He requested, please don't come out of the house. Corona is there. In the entire world, it is a pandemic situation. People are suffering. How many of you heard it? Even police stood on the roads and they give some strong, harsh treatment to the persons who came out. Is there any use? Can we appeal in the judiciary to make an inquiry? Yes, we can appeal before the judiciary to make an inquiry. If there is any fraud or other thing, you can submit an application to High Court or Supreme Court. Definitely, you can do it. There will be judicial magistrate. Sorry, judicial register, vigilance register, registrars will be there. If you go there, they will guide you how to file those complaints. And if it is related to any other department other than judiciary, then for prosecution matters, there is a department of prosecution. That head of the prosecution will take up the issue. And if it is relating to the advocacy, bar council is there to take the complaint. Like this, for every department, there will be a head of the department. First of all, that you can ask the High Court or Supreme Court when there is no other possibility to get relief for this particular issue. When there is a chance to get a relief from any other law, then you are not supposed to file a case before High Court. And most of the time, my students also used to ask me, Madam, you are saying when there is a possibility to get a relief from lower courts or civil courts, we are not supposed to go to High Court, but most of the advocates are filing High Court cases only. Why? What is the difference? Then I told only one thing to them, that go to High Court and sit in the court and observe how many cases judges are admitting. One day, I went along with my junior there and I asked him to count the number of cases. Almost on that day, almost all the cases. Judge asked him only one thing: why you approached High Court? What are the steps or precautions you took before this? Why you didn't approach so and so concerned authorities? Why you failed to do so and so thing? Then they fail to answer. Then court will direct the people to go back to the particular concerned department. And so first you approach those departments, and there definitely, if you get any relief, it's okay. If you are not getting the relief, then come to High Court. Directly, you cannot file any case before High Court. Next, police. Next door. Next, doctor. Next, who will be nearby? Relatives, friends, whoever may be, all. For which question this you are asking? Next police, next doctor, next who will be near? About confessional statements or about any other thing? This question is incomplete for me, really. Sorry, you try to ask continue question. I will answer. In these cases, she can appeal for inquiry. Yes, she can file an appeal for inquiry. Whether it is going to, she can go to High Court. There is a possibility to get, because when it is a mutual consent, she might not have taken any money from him. There might not be any big issue. The details won't be there. Really, if she led a marital life with him for a period of 4 years, 4 years, 1 year also is more than enough. One day also more than enough, but 1 day, 2 days, 1 month, 2 months may not be noticed by anybody. But if 1 year or 4 years, if two persons stay together in any particular colony, all the people of that colony will notice it. So they will come as a evidence. Not all the people. Some of those people may come forward. If she may go there and ask, and she can take the help of those people, and definitely she can file a case. There it will be a fraud. 4 years is a long period. They cohabited, even though first marriage is cancelled. Now they are in living relationship as wife and husband for a period of 4 years. Leave about the first marriage. Now they are in living relationship as a wife and husband for a period of 4 years. That ground itself is more than sufficient to file a case against the husband. Whether she did all those things or not, I don't know, because I just noticed one case in the court. For discussion purpose, I am saying. So next police next door, Sridevi, after asking the question, went somewhere, I think. So she is not responding to me. So judicially noticeable things means what? What are the judicially noticeable things? And any acts, any laws, any judgments made by the judges. When these things are coming, they are going to be taken into consideration. Murali. Good morning, madam. Just no Murali joined, I think. Am I right? So when these things, an expression relating to recognition of a particular maps, boundaries, or other matters, even in judicially noticeable things where court need not take any further evidence for them. And like that only, facts of which courts must take judicial notice. All the facts he mentioned in section 57, whereby apart from those things which the things which are having common knowledge, who is our chief minister, whether which state we are staying, we are in Telangana, this is Telangana state. Is there any need to prove this fact before the court when you are approaching? Absolutely not. Like this, some common things will be there for which there is no need of proving anything. The fact itself is a proof for it. Everybody knows it. And all laws in force. Any law in existence in the country is something. So therefore, the most important thing is this only. If you observe the petitions or plaint copies of any advocate, there they will plead about law. Is there any need for law? Yesterday also I sent the pro forma of Consumer Protection Act to all of you. I don't know how many of you followed that particular act, but what I want to tell you is, if you observe it, in that particular petition, complaint or plaint, is there any place where I mentioned and requested you to write about law at the time of presenting the brief facts of the case? Is there any single word I mentioned? There is nothing. You are saying that you are eligible to relief under so and so section because jurisdiction point of view, you are deciding the case. Pecuniary jurisdiction, and you are supposed to pay the court fees if at all it is a monetary matter, and the heading because to know whether the court is having the jurisdiction or not. For these purposes, you are mentioning those things. For remaining things, it is absolutely not necessary. But most of the people at the time of writing the brief history also they write the law. There is no need of write the law. Instead of writing the law, cruelty, write the things what is happening you and promise to note when you pay the amount, how he is not repaying the amount. These things you explain there, and court itself will decide whether that law is applicable to you or not. You need not mention so and so section is applicable to me, so and so section like this. Alage public acts passed are hereafter to be passed by the parliament. Any act made by the government is not need not be proved. Things which need not have any other proof and is a fact in public domain, recognized or undeniable by the courts shall be treated as judicially noticeable. Okay, correct. So those which are judicially noticeable facts are there. Those facts need not be proved before the court. And the next one is articles of war for the Indian Army. Indian Army ki, Navy ki, Air Force ki, whatever articles are there, those things, those guidelines they will follow. And for them also, they are also judicially noticeable things. Again, accession and the sign manual of the sovereign for the time being of the United Kingdom. United Kingdom, why it came in Indian law? I don't know why they are mentioning about United Kingdom. Parliament అయితే ఓకే యునైటెడ్ కింగ్డమ్ ఎందుకమ్మా కొంచెం ఆన్సర్ చెప్పండి అమ్మా వెరీ బ్యాడ్ దే ఆల్ ఆర్ స్లీపింగ్ Fifth point says that the accession and the sign manual of the sovereign for the time being of the United Kingdom of Great Britain and Ireland. Why they mentioned about this? Padma Susrala. Ma'am, Srikanth said magistrate is not give to preference. He said, ma'am, for that I given that answer. Okay. Then now I understood this is Sridevi. Padma Susarla, 1872. Akash, we were under British rule, ma'am. Amma. Very good. That is what I am expecting an answer from you. At least then I can understand that You all are following the subject. And next one also related to English codes only. All sales related to English codes and English notaries and other things. Next one, any publication in the official gazette. Next one, existence of the title of Government of India. Next one, divisions of time, geographical divisions will be there. Somebody asked me in the previous case whether Nepal can declare those provinces or not, like this he asked. When there is an understanding, Narsing Linga came just now only because the law is borrowed from UK. Not because law is borrowed from the UK, just because with this intention only, I want to tell one thing before concluding. When you are having these intentions, when you borrow the answers from other persons, copy the answers, along with the answers, you write your name, your father and everything, his name only. Instead of writing your name at the place of name and father's name, you write because you borrow the answers from your friend. Like that only you are answering. It is not because we borrowed from UK. At that time, we are a part of UK. They are the government means from British government. So when the government is making the law, in India, they are appointed their agents to work here. East India Company worked first. Later, government directed to and governor generals were appointed. When they are ruling the country, they are working under the control of the British Queen. For that reason, they mentioned it. It is why highest court of India at that time is Privy Council till 48 అనుకుంటా 1948 దాకా Privy Council is the highest court of 50 కదా. I forgot the year 48 or 50. Then Supreme Court established. శ్రీకాంత్ ఉంటే ఇక్కడ ఆన్సర్ చెప్తాడు. ప్లీజ్ రిపీట్ ద క్వశ్చన్ మ్యామ్. ఏ క్వశ్చన్? ఓకే అయిపోయింది ఆన్సర్ చెప్పేశారు. The question about why Britishers English law is mentioned in the section. That is the question, Srikanth. So, and the existence or title of national flag of every state and the divisions of time, geographical divisions, territories, the commencement, continuation or termination of hostilities between government of India and other states, all these things relating to administrative issues where government is deciding about the territory or the law or other facts are going to be taken into consideration. They are judicially noticeable things. So, what is meant by judicial notice? This we will discuss in tomorrow's class. Okay? Till then, bye. So no one changed it till now after independence. Yes, no one changed it because that I will discuss tomorrow. It will be a big issue again.